The following is a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys. The Siniard Law Show, answering your legal questions, featuring attorneys Tommy Siniard, Bart Siniard, and your host, Aaron Dacey. This is the Siniard Law Show.
Hello and welcome to the Siniard Law Show, where we welcome your legal questions and educate you on various areas of the law. You're getting your free legal advice from the prestigious Siniard Law Firm, a father-son personal injury firm right here in the Tennessee Valley, focused on giving back to the community through legal education. Bart Siniard's been recognized by the best lawyers in America 3 years running, and Tommy Siniard is on the list of the best lawyers in America for more than 3 decades. Gentlemen, tonight we're talking about medical malpractice.
We are, and everybody thinks that if you do medical malpractice, you have horns and you're evil. We are very particular about what we take. There's no such thing as a frivolous medical malpractice lawsuit because they're very difficult to win, and we just don't deal in cases that we don't vet heavily. We don't want to put that on some medical provider unless there's clear, hard evidence that there was an error which caused serious injury or life. Bart, the types of medical malpractice cases that we deal in, there's categories. Talk to us about that for a minute.
Yeah, I mean, we've handled a lot of cases involving medication errors, and that's a little bit different than medical errors, right. Talking about with medications, and that can be against a pharmacy for misfilling a prescription, or a hospital or a nursing home, dispensing the wrong medication to a patient. And a lot of times in those cases, it's not always the fact that they're getting wrong medicine that hurts them or kills them. It's the fact that they're not getting the right medicine. Right. They're not having that blood thinner that they need, or whatever it may be. So there's medication errors. We handle a lot of cases involving nursing home neglect and assisted living neglect, things like bed sores or malnourishment, dehydration, falls, broken bones, or we've had elderly patients actually pass away due to brain bleeds from a bad fall. So we see a lot of those. Rehab hospitals, we've seen that. The cases against doctors and nurses, really not so much, but these, institutional type mistakes like nursing homes that understaff, don't provide enough employees to take care of, the 60 or 80 or 100 residents on the floor. We tackle those all the time and have a lot of experience doing it.
All right, we invite you to submit your legal questions. Call us at 844-7000-LAW, and you can leave a voicemail, or you can email us questions@siniardlaw.com. Now to our legal tip of the week, looking out for medication errors like what you're talking about. So the prevalence of medication errors is pretty big, isn't it?
It's actually the largest category of medical malpractice. And what you have to realize is the potency of medicines today is the highest it's ever been. So it can be the wrong combinations of medicines can take you out. So you have to not only know what you're taking, you have to know the dosage you're supposed to be taking and whether it should be prescribed in combination. For instance, aspirin is an anticoagulant. So if you're already taking blood thinners, you can thin your blood so much you could have a hemorrhagic stroke. So I don't think the care is taken with medicines in any setting. The pharmacies have to fill it. We see many a drugstore case where it just wasn't the right medicine, or it's too strong, or not enough of the medicine. The facility has to distribute the proper medicine and at the proper time. You can get out of whack just not delivering medicines for a day, especially something like an anticoagulant. And so there's just a whole dose of things, no pun intended, that has to be examined about medicine, the way we prescribe and deliver medicine in our country. We're among the bottom half tier of countries in the world with medication errors. And with all the technology that we've got, it's just nuts.
You're saying that we are among the worst?
we're in the bottom half of dispensing medications properly, or people who are injured or killed by getting the wrong medicine or not getting the medicine they should get.
Yeah, I mean, Johns Hopkins University, obviously a highly respected institution, came out with a study in 2016 that said medical errors are actually the third leading cause of death in America.
Medication errors.
Yeah, only behind cancer and heart disease. Now, that was a controversial study, and a lot of doctors have quibbled with that. And it's not because they're bad people, or the nurses or doctors don't care about their patients. A lot of times it's that protocols and systems aren't set up right, or they are set up right and people aren't trained on it. A lot of times it's just simple communication errors. One provider communicating a CT scan report to another provider. Hey, this is suspicious for malignant cancer. I mean, we've had cases like that where somebody just dropped the ball. It wasn't evil, but it was negligent. And it happens a lot more often than people would think.
I mean, doctors, and forgive me doctors for saying this, but still scribble out the name of a drug on a prescription in a lot of illegible handwriting. Mine is too. So the pharmacy is left for the task of discerning that, and many times they don't call. So that's on the pharmacy, I guess, and the doctor. So they're left to discern this scribble as to drug A, B, C, or D. Drug A might be what's intended. Drug C may kill you.
So much of it, you've got the human factor, and then also all of these people seem to be overworked, right? Whether it's at the pharmacy or
in the nursing home setting, the federal statutes allow an improper dosage or medication error in 1 in 10 doses. Not 1 in 10 people, 1 in 10 doses. So somebody in a nursing home may take 20 pills a day. It's okay if 2 of those are wrong, or if you don't get them, by our federal statutes.
So when you consider the possibility something terrible can happen in a nursing home, is there anything that a family member can do to make sure that their loved one is in the right place?
Oh, well, yes, you can go online to, what is it, Bart, Medicare?
Medicare.gov, and their page has a subsection called Care Compare that's like a rankings tool.
There's a ranking system based on objective inspections of nursing homes throughout the Tennessee Valley and South Tennessee, really everywhere. That should be your first step to know, is this a worst it can be ranking or the best it can be? The other thing is the Alabama Department of Public Health used to do annual inspections of nursing homes, and they would write them up, and those inspections are supposed to be available, and I would want to see any before I put my loved one in a nursing home.
So is that something you'd have to go to the public health department to get?
No, the nursing home is supposed to have it posted within the facility.
So if you're going to visit as a potential place to take grandma,
let me see your last inspection report.
You can also find it online at Alabama Department of Public Health's website, adph.org.
So we see so much of this, especially in a nursing home setting. They're understaffed. The bottom line gets bigger the less staff you have. Most of these are private entities. We're only going to have more nursing home patients in the future as the demographics shift. So this problem is not going to get better. It's going to get worse unless somebody pays some attention to it.
Very, very good points. Now let's take a look at a local news story from a legal angle. You may have seen the news story in which a Scottsboro doctor is accused of sexual harassment against a patient.
And we begin in Scottsboro, where more accusations are pouring in against a Scottsboro doctor. We first told you about this story in April when the Alabama Board of Medical Examiners accused Dr. Alan Wayne of sexual misconduct and mishandling prescriptions. Now one of his former patients has filed a lawsuit.
Okay, so Tommy and Bart, how could these allegations of harassment affect insurance coverage?
Well, so every insurance policy has a page or two on what they cover, and then dozens of pages on what they exclude. Okay, so medical malpractice insurance coverage is no different. So one of the exclusions is you don't have coverage for intentional conduct. only negligent conduct or reckless conduct. So this could be a terrific case, but you've got the difficulty of, is there insurance coverage or is there not insurance coverage? It doesn't mean the doctor is any less liable. It just means he doesn't have the benefit of liability insurance coverage to cover him. You could still go after his personal assets. That's not something generally that we do or like to do. We call that hard money, and it makes people want to hurt you or kill you. But the fact that he did this, and there's other people stepping up, doesn't bode well for him, and it's going to be an insurance fight as to whether or not they cover it.
Bart, what is the Alabama Medical Liability Act?
Yeah, so any case brought against any type of healthcare provider, that's from a doctor to a nurse to a pharmacist to a paramedic, anybody who's a healthcare provider, that type of case is governed by the Alabama Medical Liability Act. And that was a piece of tort reform law that was passed back in the late 80s that essentially was designed to make it very, very difficult to successfully win a lawsuit against a healthcare provider. You know, there was this big media campaign that lawyers like us were suing the hospitals out of business, which wasn't necessarily true. That's a story for another day. But in short, any case against a healthcare provider in Alabama, they're difficult to win, and that's by design. We have the burden of proof, and our burden of proof is higher than it is in any other civil case. We have to prove our case with clear and convincing evidence. It's closer to like a burden of proof in a criminal case than it is in a civil case. There's expert witness requirements. We have to hire sometimes expensive expert witnesses to testify that the at-fault healthcare provider violated the standard of care. If we don't have that expert witness, we don't even get our chance to walk into the courtroom. Right. The case gets dismissed. They teach a whole law school class on it, and I can't cover it tonight. Just know that cases against healthcare providers are hard to win in Alabama, and that's by design.
There's a low percentage of the filed cases that are won, Aaron. We're proud of the fact that, 66% of the cases we take, we have a positive resolution. That's about 5 times more than the norm. But we're very picky about what we take. We want to know before we take it, can we prove this before we start picking on some healthcare provider? Is it legitimate? That's our first inquiry. We hire our own experts and have our review teams look at this and say, this is really something that shouldn't have happened before we even step into it. We don't want to be that firm that makes a claim that doesn't have any factual or legal basis.
Yeah, because you're facing an uphill battle anyway.
Right.
Now let's turn to some of our viewer questions. We have a voicemail from Michael.
I'm wondering if there's a statute of limitations on when a loved one is injured in a elder care hospital or nursing home. My mother-in-law actually left her. They didn't leave the gate up, and she rolled over and broke both legs, went into shock, and she died from it. But this has been several years now. So I'm wondering what that statute of limitations is. Thank you.
Well, there's a 2-year statute of limitations in Alabama, and it doesn't matter how good your case is or how sad a situation it is. You've got 2 years. It's like you don't get another play in the Super Bowl even though you're on the 1-yard line. There's no way to summons up more time for the last play. So it's a hard rule, 2 years from the date of the alleged negligent act. It's harder in Tennessee, it's 1 year. And some people that live in South Tennessee get banged up by that because they've heard it's 2 years because
right at the border.
Well, yeah, and all the states around them are at least 2 years. Mississippi's 3. So 2 years from the date of the alleged negligent act, and it scares us to death to get started on a malpractice case anywhere close to that time because we've got to do all the vetting, hire our own experts. So if you're walking in on a Tuesday and the statute runs on a Thursday, no matter how good it is, we're sort of hands off on that.
If you would like to sign up for Siniard Law newsletter, which provides free monthly legal tips, just scan this QR code. So Bart, tell us about your free newsletter, what somebody might find inside that.
Yeah, we send this out monthly. We've got about 500 people on our newsletter list. And we provide just free legal tips, relevant to anything from making sure you got your homeowner's coverage figured out correctly to, tips to make sure your pipes don't burst in the winter, just stuff like that. We also, provide commentary on local news that have a legal twist to them, and we share what we're doing as a firm sometimes, if we take our employees out for an employee appreciation day or whatever. But it's a good way to stay connected with the community and just, again, trying to give back kind of this free legal education so that people can stay aware of the issues they need to know about.
Kind of goes hand in hand with the Siniard Law Show.
Yeah, that's the way we call it.
Absolutely. When the Siniard Law Show returns, we will answer more of your questions about medical malpractice.
I got sandwiched between an 18-wheeler and a truck. During the accident, I lost my left leg. I chose Siniard Law because my granddad knew they had a great reputation. They were very knowledgeable. They were very sweet. We had a connection. They pretty much treated us like family. I would definitely recommend Siniard Law because they are caring and they will help you get what you deserve. If you've been injured, call Siniard Law.
Welcome back to the Siniard Law Show. Let's go over an email question. This viewer writes, my sister had a surgery to remove gallstones. The doctor said the next day that he needed to operate again, but didn't tell us exactly what was wrong. She had another surgery the next day, and somehow they nicked her pancreas. Due to the damage to her pancreas, she is now diabetic. Do you think this is a winnable case?
That's a hard call and would need more facts. And on its face, you would say, Lord, it's a great case. But here's what you got to understand. There is a defense. When this Medical Liability Act was passed, they created higher burdens of proof, and they created difficulties that didn't exist before. And one of the defenses they created is called the common complication defense. And that is, in every surgical procedure, there are common complications that appear or can appear in the absence of negligence. That's infection, bleeding, or injury to adjacent organs. So it is not that strange to get an organ nicked during the course of a surgery because it's not color-coded in there. Everything's very close. And it's the natural to say, you went in for X surgery and you got Y and Z. And sometimes it can be lethal. That would be the first defense. Now, you'd have to know more. You'd have to know who the surgeon was, how the nick occurred. Did they cover up the existence of the nick after the first surgery? There's a whole lot of questions unanswered. But the first thing that jumps out to me is they've got this common complication defense. And informed consent. When you sign, they say.
That's what I was going to say. You sign so many forms
sign here, sign here. Well, one of those little things that you sign is an informed consent. I do hereby consent to this surgery, knowing that the risk may include bleeding, infection, injury to adjacent organs. I do promise and guarantee that I will not pursue any such claims. Martha Jones. So you have to jump over that hurdle.
But we should sign those?
Well, yeah, they won't go into surgery unless you do.
Yeah.
You're sort of handcuffed.
Interesting.
But let me say this, by and large, the vast number of medical practitioners are not good, they're excellent. It's a calling, especially for a nurse or a nurse practitioner or the people that do the work down the line. They're the people that showed up for COVID. So we don't want to denigrate the profession, but we do want to weed out the bad professionals, the non-caring professionals, the drunk professionals, and they're out there. And not just in this profession, in ours and every other. We think our doctors are sacrosanct. They could not have personal problems. They couldn't be going through a divorce or an alcoholic or a drug addict. They are. And for the mistakes made in those cases, we pursue them.
Thank you, Tommy. Now let's move on to a voicemail question.
Hey there. So I had a bowel surgery about 3 years ago now, and ever since I've had a pain down in my stomach. At first, I thought it was just me recovering from the surgery, but it never went away. Well, last week I found out the pain was because of a sponge that got left in my abdominal cavity. And now they got to go in and remove it. I know the statute of limitations is 2 years, but is there anything I can do considering I just found out about this?
2 years. That we go back to that theme.
He's right. The statute of limitations almost always is 2 years, but there is an exception called the discovery rule. And basically, that would apply in this case. The statute of limitations of 2 years can be extended if there is a discovery of the negligence that simply you couldn't have discovered it within the 2 year window. And that sounds exactly like what occurred here. But you can only extend it 6 months from the date of discovery. So let's say you discover it on, August 1st, 2025. Well, your statute of limitations now becomes February 1st, 2026.
Right.
You now have a 6 month window to actually file a lawsuit. Not to call a lawyer, not to send a letter, but to actually file a lawsuit. And I should also say this, just to make it a little bit more confusing. The Alabama Medical Liability Act has what's called a statute of repose. So it has to be within the past 4 years. Like if he had discovered this 6 years after the original surgery,
there'd be no extension.
That you couldn't get that 6 month discovery extension. It has to be within this 4 year window. So this surgery
didn't have problems until 6 years later?
It's unfair. I've had to have that talk with several people during my career, where they did not know. I think it was a knee replacement surgery they had 6, 7, 8 years ago, and they found out that it was the wrong implant, and that's what was causing them to have this rare blood disorder. Well, I had to tell them, listen, there's nothing I can.
Up, yeah.
I mean, if you're past 4 years, usually when you're past 2 years, it's done. But if it's past 4 years, you're completely done.
There is a twist to this. If it's a minor, the statute doesn't begin to run until the minor reaches the age of majority.
In most cases, but in medical malpractice cases, 4 years also.
And you had a case where somebody found they had scissors?
Oh, yeah. Years ago, I was involved in a case where the surgical team left a pair of scissors in a patient. Now, interestingly enough, Alabama does not have the captain of the ship doctrine, which means you can't blame that on the doctor. There's a duty on the nurses that participate in the surgery to do a proper sponge and instrument count. And then it gets down to, oh my God, here you are suing a sweet nurse. And which one? Who had the responsibility to pull out the foreign objects? But in that case, I mean, when you look at an x-ray and there's a pair of scissors, and for the longest time it didn't do anything. It's sealed up with these giant cell scar tissues. Just like if somebody gets shot with a bullet that's not fatal, the scar tissue will just engulf it with some very hard, firm tissue, and you just live with it. And this person needed the scissors out, ultimately. But that's an eye-opening thing to see on an x-ray.
Something
and
really...
We were able to recover in that. I was just one of a team of lawyers involved in that.
Wow. We get questions of all kinds here on the Siniard Law Show. We got one that's very interesting, and it has to do with a coffin.
My mom had a funeral. The funeral home dropped the top on her casket, and we had to have another funeral the following day.
Okay, so this person they told a story. They didn't really ask a question, but do you have any thoughts on it?
You know, as crazy as it sounds, I've had some cases against funeral homes, one where the wrong body was put in the wrong casket and the wrong person was buried, and the family said, this is not our mother. And we made a pretty handsome recovery on that. There's a duty on behalf of everybody to not be negligent, to use a proper standard of care. And obviously this was something that was negligent or reckless. And it would be on the people that were entombing the body, and they're insured for that. The theory would be one that's rarely used in Alabama called the tort of outrage, when it involves a corpse.
Tort of outrage, that's interesting.
It's really the intentional infliction of emotional distress, but you don't really have to prove in every case intent. I'm sure this was not intentional, but that's the theory that you travel on. And yeah, they should be responsible, and their insurance should cover that. I mean, how horrifying would it be if they had to move the funeral back to the next day? And you're already heartbroken. So, you know, I think there is something there, sadly, but it's something that's why they buy liability insurance.
And this is something that you would potentially, Bart, speak to somebody about, and there wouldn't be necessarily a charge for them to come in for a consultation.
Yeah, we don't charge anybody, in fact, to meet with them. It's always a free consultation. And in any type of injury or wrongful death case, you know, we work on a contingency fee basis, which simply means we are paid a percentage of any settlement or verdict. And if we don't get you a settlement, we don't win your case, then we don't get paid at all. We don't send you a bill. I talk with people all day, and sometimes never actually take their case, but a lot of times I can just teach them the A, B's, and C's about what they need to do to handle it on their own, and I do that, you know, for free. We all do at our firm. And there's some situations where you may not need a lawyer, but you just need a little advice, and we're happy to talk with people about that. But even if you do need a lawyer, and a lot of times people do, especially in serious injury or wrongful death cases, you know, they're not going to have to pay us out of pocket to come talk with us.
All right. Well,
Some people ask, can I do this on my own? And sometimes in small cases they can, but I tell people, if you've got a sharp enough scalpel and a mirror, you can take out your own tonsils, but I don't recommend it.
He does say that to people.
I believe it. We do appreciate you joining us for the Siniard Law Show this week, and we hope that you are now more informed on the topic of medical malpractice. Next week, we are moving into criminal law, and we do invite you to ask us questions by email, or you can leave us a voicemail. You email us at questions@siniardlaw.com, and you can call the voicemail line 844-7000-LAW. Next week, we'll have a guest attorney, John Brinkley. Tommy, tell us about John.
So John Brinkley is a great servant to the bench and bar. I guess he's done more work for our bar association than anyone in my 45-year career. His father was a dear friend of mine. John does what we do, plaintiff's work, but what he's known for is his criminal defense work. And he's a tiger. And we're very fortunate to have him here next week and look forward to it, Aaron.
Yeah, we look forward to getting questions about criminal law. So.
Yeah, and bring the questions because everybody's got them.
Should be an interesting episode.
Very interesting. Yeah. Thank you, Tommy. Thank you, Bart. And we will see you next week on Sunday night after the late news. Have a good evening.
The preceding was a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys.